everyone. Welcome to the Windham Bench and Bar Listing Tour Stop. Chief Justice Paul Reiber is called and he's en route. Apparently he was held up with some construction, but he should be arriving shortly. And we thought we would just start maybe with brief introductions for the rest of the panelists, and then he should be arriving soon. We thank you so much for coming out, especially on a kind of hot summer evening, and hopefully the fan will help a little bit in here, but we're delighted to be here at the Brooks Memorial Library. The Vermont Bench and Bar Listing Tour is an endeavor that Chief Justice Reiber and Gary Franklin, who's president of the Vermont Bar Association, conceived last summer. They wanted an opportunity to visit each county and inviting the public to come and share their impressions of and comments about the state courts and the legal system. And also as an opportunity for us to indicate what resources are available locally in Windham County, for example, for low-income persons and any persons for legal matters. So that's kind of the rough outline for it, and then otherwise it's really to invite you to provide whatever comments, questions that you might have, and we'll do our best to answer. In each county, it's been Chief Justice Reiber and then Gary Franklin. Gary is actually unable to be here this evening, so my name is Terry Corsons. I'm Executive Director of the Vermont Bar Association, and I'm pinch hitting for Gary. And we also, at each stop, is the local presiding judge, who is the presiding judge for the unit or the county, and also the local county bar representative. So we're delighted in Windham County to have Judge Catherine Hayes, who's presiding judge in the Windham Unit, and she'll explain a little bit about her experience here in Windham County. And we also have Amelia Darrow, who's the treasurer of the Windham County Bar Association. So she's here to talk a little bit about her experience as a lawyer here in Windham County. So I may, if it's okay with you, I'll start, if you wouldn't mind, Judge Hayes, or did you want me to?
No, whatever.
Okay.
Either way.
Okay. All right, I'll wait, because I'm sure she has more weighty things to say than me, so. Okay, thank you, Judge.
Okay, so I actually go by Kate, and folks who know me know that. I even have it in my email address, so I was lucky enough to get in early on the state email addresses before they insisted you have to use your formal name in your email address. And, so I'm now stuck with that. I was appointed to the bench in 2003. Before that, I worked in the Attorney General's office, and I worked in private practice, and I was a public defender for a while. I practiced in all areas, in all 4 divisions, even including the probate division from time to time. And finally convinced Governor Dean to appoint me in 2003 after several tries. That's how it works. Most of us who were appointed as judges have tried and tried and tried a number of times before we've been appointed, and that was my experience. It was and still is an enormous honor to be a judge. I love the work. I really love helping you all. It feels like it is important and useful work, which doesn't mean I never make mistakes and I don't have regrets, because of course it's really hard. And we're all human, we do our best. The Supreme Court tries to fix it when we make mistakes, but they can't catch them all. So I am really grateful to have you all here to offer some constructive criticism, some thoughts, some questions about how we could do things better. And I have about 10 copies. I didn't know how many people would be here, and I didn't want to use our copier to make too many, but I brought a whole bunch of statistics about how we're doing in all of the divisions of the Superior Court, Trial Court. We have Family Division, Criminal Division, Probate Division, and the Civil Division. And each of those does, in each county we have those. And statewide, we also have the Environmental Court. Judge Durkin is here, who is one of our 2 Environmental Court judges who spend the bulk of their time, although Judge Durkin also helps us out in all of our other dockets as well here in this county, thank goodness. So I have those stats, and we're doing pretty well right now, actually. We're disposing of cases pretty promptly in pretty much all of those divisions, and it appears, knock wood, that our juvenile docket may actually be sort of leveling off And we're seeing something of a reduction in the number of neglect and abuse cases. That has been a chronically increasing pattern for the last several years, partly related to the opiate epidemic, but not entirely. And in general, we feel like we're doing a pretty good job, and we have a new case management system, computer case management system that I have a really integral role in helping with, and that's going to be coming to Windham, Windsor, and Orange counties in the fall, and that will be a difficult transition. So it's a lot of change for all of us, but it'll make us better for all of you and easier for you to all access cases, court information, information about calendars, information about your own history, and about how the court works, all online. You'll all be able to do that much more easily after we get that system in place. But you'll probably have to bear with us for a few months while we work our way through making that system really work and function. And we're all excited about it, but nervous at the same time. So that's my little summary of what we do. And I'll share those statistics with anyone who wants them until I run out.
So with Judge Hayes giving you an idea of the work of the court and her here as a representative of the court, I wanted to speak to you as a practitioner. So I'm an attorney here in Brattleboro. I work at a law firm just a little ways up the street. There are currently 6 attorneys at our firm. It's called Quorum Maybe Cook, Prodan, Angel, Seacrest, and Darrow. One of us. And a little bit about me. I came to the law rather late in my life, my career. I was a farmer for a number of years. After that, I worked in the music industry, actually, for a boutique music firm that was bi-coastal, New York and San Francisco, with a Brattleboro office. And I enjoyed that very much, did a lot of intellectual property work at that time. Then back to law school and did I did a semester with the UN working in the International Criminal Tribunals in The Hague. I was appointed to work under a Russian judge who was on the appeals chamber of the International Criminal Tribunal for Rwanda and for the former Yugoslavia. Really interesting work there. Came back to Brattleboro and started my practice. I do primarily work in elder law and estates and trusts, and some property work and business law. I still do a little bit of intellectual property work as well as part of my practice. I serve as treasurer of our county bar, the Windham County Bar. We have about 120 members of our bar, which is pretty good for a small county in Vermont. About 60 of us are active at this time, meaning we come to monthly lunches at the American Legion. We get together for bar events, for continuing legal education courses, and work to provide information to the community in ways that we can be helpful, whether it's in assisting people act as pro se in their, say, family court cases, or to get some information about probate, or about, let's say, long-term care planning. There's information sessions that I have held, whether it's at the brown bag lunches or talks right here in this room. And many of the other practitioners in our bar do that kind of community work for information purposes and to support those of you in the community who may not have the resources to be able to hire an attorney, but want to proceed with some understanding of how the process works and a little bit of what you can do to protect your rights and your own interests. So tonight I'm just here to listen and to answer any questions you have as a representative of the practitioners, and anything else I can do to help. So thank you for coming.
Thank you, Maria. And like the Windham County Bar Association, one of the goals of the Vermont Bar Association, and we love to work closely with the county bars, and we're very lucky. The Windham County Bar Association is a very active county bar, and lawyers do much good pro bono work or low bono work to assist people so that they can have access to justice. I was going to just kind of highlight briefly a couple of things that we offer through county bars and then statewide. One at the, and I think it's actually here at the Brooks Library, we have these cards that provide information about legal services that are available for whatever income level a person is. We have them at all the state courts and then at least at one public library in each county and at the VA centers. But just to give you an example of what is available, for low-income persons, we have something called VT, Free Legal Answers. It's an online legal services service where you can go online, post a question, type out a question, whether it's in civil, probate, or family. Volunteer lawyers then log on. They can review the question and then answer it online. You get an email back saying, here is your answer, but it's a way for low-income persons to get access to lawyers with to answer their questions. Then if you might not qualify for the free VT free legal answers, maybe earn a little bit more, there's also a program called Modest Means, where if you qualify for that, then again, lawyers who are willing to participate in the Modest Means program charge just $75 an hour instead of 2 times or 3 times that. So it's a way to get legal assistance for that income bracket. Hello, Chief Justice, how are you?
Sorry I'm late. Sorry I'm late. How are you? Okay, thank you for holding the fort.
Yeah, sure.
We're just finishing up our introductions to them to you, so make yourself comfortable. And then for no matter your income level, there's also the Vermont Lawyer Referral Service. That's an 800 number. If you have a legal matter, you indicate what the broad area is of the legal matter in the area where you work. You'll be connected with an attorney. And the most that an attorney can charge for the first half hour is $25. And you can get a lot of information in a half an hour asking those questions. So those are kind of basic services that are available throughout the state. Then we also have in Windham County and a number of other counties what is called pro bono assistance in either landlord-tenant, foreclosure, or collection cases, or involuntary guardianships in the probate division. And that's where the Vermont Bar Foundation has given a grant to the Vermont Bar Association that pays lawyers a reduced fee to assist persons who are low income. They pay nothing. The grant pays the reduced fee to the attorneys, but that's a way to get legal assistance in those categories of cases. And we found that landlord-tenant, foreclosure, and collection cases comprise about 70% of the civil docket statewide, so it's a majority of the cases. So that's another opportunity. Also in the juvenile docket, the Vermont Supreme Court has given us a grant where we can assist adoptive parents who are adopting children in the juvenile system and they're working out a post-adoption contact agreement. So there's free legal assistance available in that instance as well. We also have for any school or civic group in the state, if you have any in Windham County, for example, who are interested in pocket constitutions, we come and provide complimentary pocket constitutions and a basic overview of the United States Constitution. To any school group or civic group, we have the pocket constitutions here. Help yourself if you would like to look up those amendments that are getting so much publicity nationwide. And lastly, we also have an On Your Own at 18 booklet that's basically a summary of all kinds of areas of the law. We provide them to high school graduating seniors and to also young persons who are aging out of the juvenile system. Same thing, if people would like a presentation, we come to any school or group that would like, and these are also available complimentary to persons in that age group, although to be honest, when I've dropped them off at schools, the people in the office, can we get a copy too? So they're available and they're on that table. So that's just kind of a summary of some of the resources that we hope to help ensure access to justice for Vermonters. And with that, Chief Justice.
Thank you, Terry, thank you. And has everyone been introduced, you all? Yes?
It's your turn.
Oh, it's my turn? So I'm Paul Reiber, the late Chief Justice to this meeting, and I apologize again for that. You are the last county, but not least, by any means, that we're visiting. We've done all the other counties over the last, about 10 months, I think. Regrettably, Gary Franklin, who's the president of the bar, was not able to be here this afternoon or this evening. And I am sorry about that because he's been very faithful to these across the state. There have been some memorable meetings, many of them much more sparsely attended than what I would say this meeting is. We were in Lunenburg, Vermont. I'd like to reflect on that meeting in particular. Happened in the middle of January. Terry and I got there about 4:30 in the afternoon. It was pitch black and about 10 below zero. And I think we had 4 or 5 people that showed up, which was really great. And one of the, let me say this. The reason we did this, Gary Franklin and I had the same idea, it turned out, which was to try to open up the courts and the profession to the public, and without any specific agenda. So we come here without any agenda. Really it is to give people in the communities around the state an opportunity to be heard, to ask questions about the way the courts work, the way the profession works, and specifically we decided to do these meetings in public spaces, not in courthouses. And I have to tell you one quick story. It's very interesting because I have an intern this summer from Vermont Law School, a second career guy, and he worked for USAID for about 10 or 12 years before he started to go to law school. And I told him about this project. It turns out he was doing very much the same thing in small towns in Central American countries, where they would specifically bring members of the government into public spaces to try to create a dialogue between the public and not just the courts, but also law enforcement as well. We don't have law enforcement here, although, Deputy, I'm glad to see you, and thank you for coming. So that's really all I have to say. Terry and I, and there may be some other attorneys here, were at the federal court yesterday afternoon and had a terrific session that was sponsored by Judge Crawford, one of our federal district judges here in Vermont. And I can give you more background to it, but basically it was to invite lawyers who had any interest at all to provide services, either pro bono or low bono services to victims of domestic violence. It's a project that really comes out of a bill that was passed in Washington last year. And I thought it was well attended. There were presentations made by a number of interest groups as well as the state's attorney, and talked about a couple of defenders presented as well, and they talked about the stresses that are in the lives of folks who face these problems with domestic violence, and the need for counsel beyond the lawyers that are provided in the criminal justice system, which is where these cases go. So anyway, that happened yesterday. We can I could review my diary going back a week if you like, or we could talk about baseball if you want. I don't know. So I'd like to open questions. You got a question?
Yeah, no, I actually have some. I'm actually very, very disappointed with the criminal justice system, not only in the state of Vermont, the United States, based on disabilities and everything. I have 100% disability, which was given to me in May. I have a learning capacity of 4.7 grade level. I have continued to try to represent myself and have used $18,000 of my own money in 25 years to hold a company accountable in the state of Vermont. They sent a police investigator from their insurance company, Liberty Mutual, out of Boston. He interviewed me a year ago. He believed me. It's been to the Attorney General, Department of Labor, Bernie Sanders, Zuckerman apologized. It's called the Ben & Jerry Corporation. I was beaten with a board working for them, along with a woman and another guy, and we sustained injuries, okay? All medical documentation is here, from psychologists to therapists to the police, the state police that came and saw me said it needs to be a resolution. The judge had originally handled this when I took him to small claims court, and it said I was distraught as I explained what happened to me. He said to Ben & Jerry's, you have a meeting amongst both of you and you get back to this court with a meeting. They never chose to have a meeting with me. This has bothered me for 25 years. I've almost taken my life over this, and I have never got justice. Every small law firm here in the state of Vermont has told me, we don't have the money to go up against a $1 billion company. Unilever's worth $60 billion. The Attorney General's office, TJ Donovan, says, unless there's unusual circumstances. The psychologist's report says there's unusual circumstances that prevented me from coming forth because I was abused as a 12-year-old kid, a 5th grader. And I cannot get justice. The disability people said we don't have the resources. Every law firm won't take it on. Bernie Sanders didn't want to get involved. Peter Shulman, all of them, because they took money from Ben Cohen and Jerry Greenfield. Ben Cohen, and when he was in Claremont, I gave him all my reports and figured maybe he would say he's sorry. Nobody has apologized for the assault that took place. It's a crime in the state of Vermont. And I can't believe there's not a law firm out there willing to hold. There's 25 years of documentation I have about a foot thick at home. And from every medical report to people's testimony, the work has already been done. And so I have to live with this every time. I got re-triggered the other day just because I hear, Jerry's going to be in Brattleboro. This is going to happen. And I get worked up again because there's no resolution. So I just want to throw that out there. But this company has completely lied. I was propositioned for sex, made to sit there until 1 o'clock in the morning. My shift ended at 11. The lady says, you want to have sex with me? I says, no. She says, get your shit and get out of here. And the other guy had to have sex with her. And they brought a stripper that performed in front of 30 employees. And they have never apologized. And I don't know where to go. I really don't. Because,
I appreciate you coming here to talk to us. We're not, this is not a court of law. We're trying to, and it takes courage for you, I'm sure, to tell your story, and I appreciate you doing that. There's nothing that I think we can do about that, and I hear that I hear what your concerns are and your complaints. There are lawyer referral services at the Vermont Bar Association. I don't know if you've tried those.
I've tried 18 attorneys over 25 years.
Yeah, there's a referral service at the VBA in Montpelier that's in the phone book. You might try that.
I actually have. TJ Donovan was going to get back to me when he was in Springfield, never did.
No.
I actually have no trust in the legal system anymore. When you can get assaulted at your place of work and get away with it in the United States of America, something's wrong.
I'm sorry to hear you say that.
Yeah.
And I wish you well, and I do appreciate you coming here to speak to us about it.
All right, well, thank you very much.
Thank you, sir. Thank you. Anybody have anything else? Any other comments? Yes.
I'd like to read a statement if I could. It's about 2 minutes.
Sure.
Okay, thank you.
Would you identify yourself?
Sure, I'm Brian Cohen. I live in Westmoreland, New Hampshire, and I work in Putney, Vermont.
Okay.
And I'd like to speak about the prevalence of judicial discretion, and in particular, implicit bias, particularly in family law. Recent studies have shown a high correlation between judicial discretion and implicit bias. When judges tend to rely on intuition and common sense, as they do when they ignore governing statute and case law, they tend to dismiss cases they disfavor, interject their personal opinions, and allow irrelevant or inadmissible evidence to influence their decisions. While judges may deny the influence of emotions, emotions are a part of intuitive decision-making, and judges may decide an issue of statutory interpretation favorably for the defendant because of their own identity and their own experience in response to certain characteristics of that individual, and show bias toward litigants from their own group, gender, region, or race. In some cases, such as spousal maintenance, the lack of guidelines and structure prevent consistency and predictability in family court has led to remarkably disparate and inconsistent judgments throughout the state. Clear guidelines would free judges from the existing perception, right or wrong, of implicit bias, particularly the perception that judges tend to rule against men or minorities in family cases, that judges hesitate to trust fathers as custodians of young children, or that husbands are inherently more likely to recover from an asset division. An example of the successful use of clear structures in family law is child support guidelines. The courts use them and they work. In other cases, such as the enforceability of prenuptial agreements, judicial discretion can have ruinous and unforeseeable results. Though there are, in fact, only 4 factors under which a binding contract can be legally nullified: fraud, duress, factual mistake, or unconscionability, judges in family court have set aside legally valid prenuptial agreements on the grounds of public policy without citing relevant case law, disregarding governing statute, while removing the guarantees and protections that legally binding agreements outline. Errant, speculative, and prejudicial decisions by family court judges outside of established statute create outcomes that are well beyond the intent or spirit of the law. It is in the interest of the state to enforce legally binding contracts and to require judges to uphold laws determined by the legislature, not invented without legal precedent by the judiciary. In moving toward predictable, consistent, and equitable family law in Vermont, the state must make sure clear guidelines are in place, that judges follow those guidelines, and that the legislature retains only those judges who respect the laws that the legislature itself has written. Thank you.
Thank you very much. I appreciate those comments. Implicit bias is a serious concern. And as a matter of fact, we had a session at Judicial College a couple weeks ago, target exactly about this. It's a very important matter, and I appreciate your comments. Thank you. Thank you. Okay. Anybody else? Yeah.
Could you say more, I'm sorry, Justice.
Call me Paul.
I was going to say Paul. Could you say more about the college that you have every year for judges?
Yeah. We you know, it does depend upon how the budget is going. So I hate to bring this up, but it's true. It's just some years it's longer than others. One year we were just a day. This year we were 4 days, which was great. Which is really the way the college has been run traditionally in the past. It's 25 years old, Kate, something like that.
Yeah.
We just celebrated, I think, a year or two ago, the 25th year that we've been doing it. For many years, it was at the Breadloaf campus of Middlebury College. And there's a great story about that. Is Patty Whalen here? Probably not. Patty was a member of the International Association of Women Judges, and wound up as helping to bring 4 women judges from Afghanistan over to our judicial college every year for about 10 years, I don't know, something like that. It was State Department funded, and it was a wonderful thing. And many of them were in this community because I think they were in Vermont for 2 weeks. Do you remember this, Ann? Yes. Yeah. Anyway, the purpose of the effort, and I would tell you every state does this. We're not unique, but not everybody does it the same way. But the purpose is to refresh ourselves about the law, about issues in the law that are very current, emerging issues, There actually are sessions dedicated to family law, to criminal law, to civil law, probate, all the way across the board. All of the judges in the state attend, not necessarily for the whole 4 days this year, but so the side judges were there, the probate judges were there, all of the merit selected judges were there along with the Supreme Court. There was actually the implicit bias part of this was the first day. It was the whole day, wasn't it? I think it was the whole day, or it was most of the first day. Karen Richards, who you may know, and she was terrific. It was really, really very, very well done. And this was to a group that not only included all of the judges, the categories of judges that I just identified, but we also had law clerks there from across the state. So it was quite inspiring. But that is typical, is what I would tell you. That's very typical for how the college is run. There's a committee. Judge Hayes may be on it. I don't. You're not. You used to be. No. John? No.
The committee I've managed to.
Tom, you are. Yeah. And the committee meets during the year regularly to come up with an agenda. Speakers. Very frequently, our own judges are the ones who do the education, because we have some terrific educators on the bench. So it's a great effort, and it's a very important effort to keep current with the law. You know, that's why they call it the practice of law. I mean, you can think about the same thing for the bench. The law is evolving, and it's not a static discipline. I mean, you all in the legislature pass new laws. We need to keep up with that. So it's a very important undertaking. Training and education is high on the list of our priorities.
I did get some questions from there's a group of foster parents over here, and a few of them approached and gave me some written questions. Yeah, before we started, so I could talk a little bit about that if people are interested.
Kate, before you, I just want, maybe this could roll into your question. I'm Chloe Lear, I'm the director of the Winston Prouty Center, and I just wanted to bring up that issue of child development and how that gets considered from the bench. We know that brain development is happening so early, and so considerations around with really young kids, sort of what training, what considerations, if there's more we could do in the state to really take that into consideration, and I think it is probably related to that. So let me just throw that in with you.
Actually, I'll start with that, because some of the questions relate to what do judges know about kids? A really important question, and the answer is that is a key part of our education. Since I've been on the bench, I've gone to every judicial college, except one when there was a medical emergency and I couldn't go. But I've gone to virtually every judicial college. They are always amazing presenters. We get folks from out of state. We've had presentations on trauma issues at least 3 times separately, like full day on how does trauma affect children, how does it affect adults. We've looked at secondary trauma, because we deal with a lot of tough stuff. We see folks who are really struggling and have to make decisions about things that are hard to even think about. And so we're affected by trauma ourselves, and we need to be careful not to allow that to affect our decision making in ways that would make us less than objective and not fair. Child development, brain development, we've had presentations on neurological development, especially around adolescence, and how difficult it is for folks who are between their teens all the way up now, they're saying to close to 30, because their frontal lobe has not fully developed, their decision-making abilities are not as sharp or as clear as those of us who are adults in theory, although sometimes I wonder myself. We all have those days when we go back to that adolescent impulsivity. So we do get training on those issues, but we could always use more. And we are, as a bench, I think we're open to that. We want to know more. There is an education committee that if folks in the state have suggestions about presenters who would be really powerful and could give us the information we need to make better decisions. Pass that along to, I think Judge Zone is actually still the chair of the Education Committee. Every year we have presentations both at Judicial College, and there's a Family Law Day for all of the judges who are rotating into family court every fall for a full day. We get training on developments in family law, focused on whatever the most significant changes that have been in case law or in statutory law. Last time we spent a lot of time talking about youthful offender issues because we have a brand new statute on that. So we had to spend a good half day of the Family Law Day trying to figure out how does that work, make sure we do it right, and that we're offering youthful offender treatment to the youth who should get it and who it's safe to offer that alternative to. But foster parents want to know, how does this system work for them? And I have to say, I am so grateful to and always so impressed with the foster parents we have in this community. It's an amazing group of people who are willing to step up and be there for kids who are in families where the parents are just not able to care for them for some period of time, and it requires enormous sacrifice for the foster parents to offer those services. We always need more foster parents, since we have a group here, I'll just sort of say that. I've been hearing it on VPR occasionally, and it's really an important message. We do need foster parents. And foster parents are still not accorded full party status in our system. There are a lot of reasons for that. In juvenile court, the parents, the child, and the state are all represented. They all have attorneys. The child has a guardian ad litem. The foster parents are there as helpers, and they don't actually even get to be part of the court process until there's actually been a finding that the parents have not done a good enough job, haven't protected the child, have either abused or neglected or failed to provide for them, and that we need to do something about it, and the child needs to continue to be in DCF custody. Only at that point do we allow foster parents to attend hearings. That means they've missed a lot. They've often missed the bulk of the decision making. They haven't heard all of the evidence that led to those decisions, and it puts them at a disadvantage, and they don't have counsel, and it's difficult. That would be a great opportunity for the bar to step up and just provide some help. I know foster parents are getting volunteer services from the bar for situations where there is a proposed termination of parental rights and the parents still have a strong bond with the child, so we need to have some kind of post-adoption arrangement for the parents to keep in touch with the child or be aware. And the foster parents who are proposing to adopt the child have to have an opportunity to talk to an attorney about what that means, because it's a big decision to enable the parents whose rights are being terminated to still have a connection to the child. It's so complicated. I think foster parents have strong connections with the attorneys general who bring the termination of parental rights cases. And I have found in the termination of parental rights cases that I've had to hear, and I hear a lot of them, unfortunately, that the foster parents' testimony about how the child is doing, what the child's developmental needs are, what their connections with the community, what's going on in their lives, is among the most powerful and important testimony that we hear. And I think any judge who does this work would agree. So your involvement in the process is already very important, and it's really helpful. One of the questions was, why don't we always agree with the DCF when they ask for termination of parental rights? And because that's our job. And frankly, the state has to prove that a parent's rights should be terminated by clear and convincing evidence. It's a very high burden. And we want to keep families together if we possibly can. We want kids to maintain a connection with their parents if they possibly can. If the parents have done a lot of work on making progress, and we see parents who are struggling with opiate addiction, with mental health issues, with educational issues, with lack of housing, with their own trauma and histories of having been abused and neglected themselves, we have to take that all into account. And we have to take into account the fact that, frankly, kids love their parents. Almost no matter what they do, they love their parents, and cutting that bond is an enormously difficult and painful decision. So we can't make it unless it's absolutely the right thing to do, and there's no other reasonable choice. So that's sort of a summary of how that works. And I think that addresses a lot of what was in the top two questions that the foster parent group wanted answered. There's a lot of great questions here. I would encourage the foster parents to talk to the group, to talk to our GAL coordinator, and perhaps to our family court manager, to see if there's some way that we could meet and talk more in another setting. Because foster parents are a key part of our process, and they have the right to have a better understanding of how it works. So thanks for those questions.
I was going to ask you, you said that, because I don't understand the process entirely, but that at some point the foster parents they're not allowed to be part of the process until a certain point, but that they're, where does that come from? Is that just the traditional way of doing it? Is it a legislative issue?
It is.
Okay.
The juvenile court system is confidential and closed. for the
Even
most
to the
part.
foster parent?
Foster parents are only allowed, and this was a relatively recent change. I think it was maybe about 5 years ago that foster parents were allowed to attend post-disposition hearings. And now they are allowed to attend the hearings after we've issued a disposition order, after there's been a finding that a child's been neglected or abused. But only then, only after those findings have been made. And the reality is, up to them, child could be going home at any moment. At that point, it's become a little clearer that maybe it's going to be a while and that they're going to be staying in foster care. And I think that's probably why the legislature, after hearing testimony, I'm sure from a lot of people, decided that's probably the right phase at which we should invite the foster parents to start attending, because it looks like we're here for a while and for a long haul, and that we may not achieve a permanency goal of getting the kids home anytime really soon.
And do you agree with that legislative decision?
I will tell you
Sorry to
that
put you on the
Judge
spot.
Davenport, several years ago, when we were rewriting all of the legislative statutes about juvenile court and restructuring it and making it a lot more sensible and thoughtful and making the structure work better, her view was perhaps we should open the whole thing up to people. It should all be public. We shouldn't keep it private. We should invite the public in. But that's hard on kids, and it's hard on the parents. So there are pros and cons for both sides.
Thank you.
Question is two-part. First, I'm going to premise what's on it. When judges retire, they're allowed to come back, correct me if I'm wrong, and sit on the bench, even though they're retired, and even though they're not reviewed by the legislature. And I suppose they go to judicial college in terms of training. And now we have all of us old retired lawyers who still, 65 is and 55, we can still function. But most of us go on, thank you, inactive status, because we don't want to pay $400 a year for a license. And we really don't want to do all those CLEs that some of them are kind of stupid.
No,
And I used to teach law.
no.
So here's my question. Could we make some kind of a license that allows the retired lawyer to go in and help with all these pro bono cases? Okay, you got my answer already.
Yeah, well, coincidentally, a year ago, attorney licensing changed the categories of licensure to include a pro bono emeritus license. Right, which basically means that it doesn't matter what retirement age, but if you retire as a lawyer and wish to continue practicing, but only for pro bono cases, where you're doing it for free, you can do that. It's a much lower annual fee. I'm going to say $60, I think, for 2 years. And then I think it's 8 hours of CLE per year. And many of those CLEs that we offer for people doing pro bono cases are free anyway.
Okay, you proposed it to Judah.
Oh, no, it's been adopted.
Yeah, yeah.
Well, see, I'm totally out of it. She won't be very
So I'm happy to get you the information, and I have that status, so I can vouch that it's, it's in effect.
It took.
Yeah. But there's a malpractice insurance question.
Oh, well, actually,
yeah, what about that?
well, no, if you're doing pro bono cases through one of these programs that I described, we have a blanket policy that covers the malpractice. So you don't have to have a...
Well, thank you for showing up here.
Well,
Thanks for asking a great question.
It's a very new thing.
Okay.
Yeah.
And the truth is, the Vermont Bar Association, as you know, is an incredible
Generous.
institution in this state. It's independent of the Supreme Court. In many states, the Bar Association is aligned with the Supreme Court in that state, in that jurisdiction. And but that's not the case in Vermont. It never has been. As a matter of fact, our VBA is one of the oldest state bar associations in the country, and sponsored very soon after the first American Bar Association ethics rules were adopted in the 60s. It was the Vermont Bar Association that came back. Not the Supreme Court, not the Vermont Supreme Court. It was the Vermont Bar Association that came back to Vermont from that ABA meeting. And I think within 60 days, 90 days, something like that, at the annual meeting of the Vermont Bar Association, the VBA adopted. Now they were not, they were hoarded aspirational, yeah. But in any event, this was the first state to do that. So I'm very proud of our Bar Association, and I think the work that is being done here is additional evidence of that too.
I'll
Yeah,
go one just as an observation. As a long-term guardian ad litem, I just started doing some mental health cases.
Thank you for that.
Which in Windham County, of course, mental health cases are a big deal, or everywhere. But I have to say I'm totally baffled, despite Bridget Lynch's best efforts and Diane's, to make it clear. This is just an observation that what's in family court, what's in criminal court. I've sat between the two of them, hoping someone will tell me what to do. But I think the guardian ad litem's role in those could be either more active, or a lot of times they're not necessary. I mean, I spend most of the hearing just learning stuff, which is fine. I'm very interested in it, but there's some disconnect there, I think. But I'll tell you more in a year when I do more, perhaps. It does seem confusing, I think, as to what we can contribute to the proceeding. Is that not clear?
I have to make a confession. I'm a little hard of hearing.
Okay.
I have hearing aids, and
I speak. I'll make
ate one of them the other day.
I speak quickly, and I mumble.
She's
so.
hearing better now.
I mumble and speak quickly. Guardian ad litem role in mental health cases, especially because many of the clients have things going on in both criminal and mental health, and so it just is like, what can I do here? I don't know if that's a legislative issue, a judicial issue, an issue throughout the country, but so it's an observation that it's pretty crazy.
Well, you know, these are jurisdictional questions about where cases are filed,
right.
And there's a lot of structure, a lot of legal structure around that. There's certain office holders who can file these matters, depending upon what exactly they are, whether they're criminal, whether they're family, whether they're child protection cases. So there's quite a lot of structure around that, and you know, I would tell you from trying to look at it from a very 20,000-foot view. The logic behind that is to make sure that the people who do have responsibility to pursue claims against individual members of the public, that those people are very responsible to and accountable to the electorate. So it's not an easy question that you're raising. There was a domestic violence docket here for a while. It's not here anymore, right?
We don't have a specialized court any longer, but a lot of the
Yeah.
procedures and practices that were put in place when we had an intensive domestic violence court here are still in place and are really, really helpful and help to keep people safe.
But there is a marrying of sorts between the criminal docket and the family docket in some of those cases?
So
No.
much. We are not able to do the one judge dealing with both dockets as consistently as we were able to do when that was in place. And that did have its advantages. So I don't think anybody's doing that statewide.
No, I don't think anybody is doing it. Listen, let me just say again, though, I appreciate what you do. For those of you in the room that don't know about the Guardian Ad Litem program, we are benefited, the state has benefited, the courts specifically, by the work that GALs do. They stand up for kids in court, they're volunteers, and you all deserve a tremendous amount of credit for what you do.
And we need more of those too.
Yeah.
Just saying.
Diane's having new training.
Always need more.
September dates
September.
for training.
There we go, yeah.
It's very rewarding. We have some guardians ad litem here who will tell you about it.
Anybody else? Yes, Senator.
So we hear a lot about, on the Judiciary Committee, about our 14 different systems of justice in the state. And I know that we have different state's attorneys, so we have a different approach by every state's attorney, and we also have different judges and all this. How do we have a more consistent and
Well, if we, I know this is a concern for us too. This is part of the reason for the training in judicial college and all the rest of it, is to try to make sure we are harmonizing our practices and procedures as much as possible. Tom Durkin is a good example of a system that we adopted in this state, not the judiciary, but the legislature, that created a court of statewide jurisdiction. This is a fairly remarkable thing, and I think it's something that we ought to think about emulating in other discrete areas of the law. And Judge Durkin could tell you better than I can about how his court works, but basically they go out to the individual counties where the disputes are pending, and they sit there, but they have a central repository, if you will, of where all of the filings come and everything else. This is the kind of system that I have said before, maybe not to you, but to your colleagues in other contexts, that I think we ought to think about in the child protection docket, where we have seen just an explosion of cases across the state related to the opiate problem. If we had maybe not a court of statewide jurisdiction, but regional jurisdiction, I think we might find that we could address some of the backlog that we've got in some of the counties with dedicated resources. This is something that the 7 million that got carved out, the four people, I don't know what we call them. We can talk about who they are, but this is something they're looking at, I know that.
Chief, may I just add to that?
Yeah.
I just wanted to respond more to the question too. I'm happy to talk to anybody about how the environmental court works, but I would note that I've been on the bench now, I'm in my 15th year. And when I started first in the environmental division, and before that I was a lawyer for 20 years, I went around the state a lot. Now I go entirely around the state. And there used to be 14 silos in the judiciary. I can attest to that. You had to understand when you're going into a new county, what was the rule in that county and how things worked. And if you were from Brattleboro and you suddenly found yourself trying a case in St. Johnsbury or St. Albans or Burlington, you had to learn. And I think that thanks to the chief and a commission that he put together what is it now, Chief, 7 or 8 years ago?
9 years ago.
9, okay, so I'm wrong. My personal observation is there isn't that silo approach much at all anymore. I go into each individual court in different counties, and there's a system in place and procedures are in place that all counties, I think, pretty much are following. Now, there might be some aberrations a bit, but I think you'd find that silo effect that we used to reference is not there anymore. My 2 cents.
We still hear.
Yeah, oh yeah, and I hear things about the environmental court, and I say, well, wait a minute, didn't that happen in like 1992? You know, but I'm, you know, I'm glad that people offer the comments, because then you can have a dialogue.
Hi, yeah.
Kind of going back to like foster care and child protection.
Yeah.
I've been kind of seeing that more kids are going back on CCOs, and coming from like the medical profession of a mother-baby nurse and seeing parents that are doing cocaine up until the baby's born, and then baby goes home at discharge. What kind of like makes you like determine if they're actively doing drugs until the birth, what makes them kind of be able to take that baby home? When like pediatricians are going, are we seriously sending this baby home?
If the pediatrician's not in court saying, are we seriously sending this baby home, then I don't know about it. I can only make decisions based on the evidence that's presented in court. So if folks have information that they think it's really important for DCF to present, they should make sure DCF has that.
They've been DCF involved. Like it says DCF twice, you call DCF, and they're like, no. Court says they can go home. So we just get confused at work a lot of time, and I'm also a foster parent, so it's just really confusing to be like, why is this child going home when the parent is actively using drugs at this moment? Maybe not like 24 hours, in 24 hours, but 24 hours before, and baby's testing positive. Why are they going home?
Well, the judge is right. The process depends upon evidence, reliable evidence in court, number one. The second thing I would say, and I've said this in many other contexts, you know, these child protection cases and the decisions that judges have to make are among the most difficult choices that a judge has to make. There is no guarantee in the process. It's just the way it is. We can't guarantee it. If you want to try to create a system where there's a guaranteed result, it's not the one we have. It's not the one we have. We can't guarantee. This is a system that is driven by human judgment, and its great strength is because of that. If that makes any sense to you, it really is. That is the great strength of it. But the vulnerability to the people that we serve is that we're not perfect. The system isn't perfect. We're not going to get the answer exactly right. And if you want a system that does that, believe me, look at China or some of these other countries where there is no process, there is no due process, there is no protection, the kinds of constitutional protections that we have. But I would tell you that these choices that the judges have to make, the trial judges have to make, are among the most difficult ones that they see. I think the most difficult ones they see. Because we all are very concerned about the fragility of the kids in this state. It's a terrible thing that has happened, and that children are being exposed to.
Can I just follow up on what I think what I hear you saying is you witness something that's
We witness it all the time.
wrong. Whose responsibility is it to get it to Judge Hayes? What's the process? Whose job is it to do that within your institution?
So we have lists of moms that are on watch. Like the doctor's office will say, like, we call them our pink slips, and they say like methadone, drinking, whatever, no prenatal care. So, and then we'll say usually DCF case open, notify DCF at time of birth, probably requesting custody. So
I'm
we.
sorry, I'm talking a little slower, I'm also deaf. So you don't- what?
So it'll be like, it will have like a checkbox, and we just kind of check, and
Yeah,
it'll say
okay, so
DCF case,
okay.
whatever, notify at birth. And we do that. Baby comes, notify DCF, and then it's,
But when the baby goes, does DCF learn of that?
yeah, that's all.
So somebody has a job to
We,
do that?
yeah, they have to come and, I don't know, just the whole DCF.
But then that doesn't get to you?
But it-
There's a
It is, because
breakdown
they're
at
going home
DCF?
on the continuing care order, which is by the court, right? Or the continuing, whatever it's
It's
called.
conditional
Conditional
custody.
custody order.
A CCO is a conditional custody order. And oftentimes when a parent has an addiction, and if they're on medication-assisted treatment, they're following the doctor's orders, they have gotten proper prenatal care. Frankly, if in a situation like that, there wouldn't even be a case filed, because mom's doing what she needs to do to address a serious illness. If mom is struggling with her medication-assisted treatment, is going out and relapsing, or has not been as consistent in following through with prenatal care as he or she should have been. Sometimes we do get a CHINS case filed, but we have to find that a return of custody, or actually in this case, this is a brand new baby, so the child has really not been anybody's custody except mom's belly up to that. But we have to find, in order to take that child away from mom and say you cannot take this child home, we have to find it's not safe. It is not safe. That this child will be unsafe and at risk of immediate danger.
But do you get a medical report that you regularly look at, so you know whether that child
Generally,
is...
when we get those emergency requests, there's not a medical report. There may be a few notes, a few summaries from the nurse's notes about what happened at the time of the birth. If mom was really showing that she could not care for the baby, dropping the baby, nodding off, not able to nurse the baby, really emotionally, out of it, or struggling. All of that would be important. And sometimes we do say this child can't go home with mom. And sometimes we say we're going to give it a try. We're going to send this child home with mom. We're going to put conditions on her custody of this child. She has to follow that. She has to keep in touch with the doctor. She has to follow through with all prenatal care. She has to report to DCF. She has to allow DCF to come and visit her anytime of day or night, with or without notice. She has to provide urinalysis results. She has to go and get a urinalysis anytime DCF asks her to do it. Those would be standard conditions in a situation like the one you're describing. They're very, very fact specific, these kinds of orders. And they are, as the chief said, it's really hard. And we can only make the decision based on the information we have. So I certainly encourage medical professionals to provide as much information as they can to DCF. Report again. If you see disturbing issues, don't just report once. Keep calling if you see mom not able to provide for her child. Doesn't have to be limited to just calling once and saying, oh, well, we told them this isn't a good mom. We don't get to say, oh, you're not a good mom, so we're going to keep your kids. It needs to be an ongoing, constant, chronic issue, and we need to have really pretty convincing proof that they can't take care of this baby, because none of us would want that to happen to us. And there are constitutional protections for parents. Parents have constitutional rights to have their children with them if they can do so safely. They don't have to be perfect parents. They don't even have to be very good parents. If they can parent, then they should have their children with them. That's how our system works.
Thanks for your concern.
Yeah,
Can I just ask-
I certainly do understand your concern.
May I ask a question?
There was another question behind you. So,
Yes, I'm Joe Cook. I'd like to speak about the probate practice just for a second. And my hat's off to all the probate judges, which some may not know are actually elected officials. And my concern, much like Jeanette's, is what I perceive as the lack of consistency between the probate courts. And what I see going on is there's sort of an effort underway to merge or make the civil rules applicable to the probate division. And I find that we're getting what I perceive rather to be unreasonable requests. For instance, when somebody is consented in writing, to, for instance, an accounting, we're then asked to file a certificate of service that they got it. Well, it seems to me it's self-evident that they got it because they would not have consented otherwise. I've actually requested an audience with the Probate Oversight Committee. I've not heard back in an effort to see if we can sort of streamline this. I think there were some proposed rules concerning certificates of service that I saw recently that I thought were rather incomprehensible. I think we all need to recognize that much like the family court, fully half of the parties that appear in probate court are not represented by counsel. And if we as attorneys struggle to figure out what's expected, I think that what I see happening is there's and I saw Judge French here at one point. She's done a tremendous job cleaning up the backlog, in this court. But what I perceive is the court is sort of making the work unnecessarily, and some of these documents that aren't really necessary in my mind. It takes court time to request them. It takes attorneys time to respond, and then you've got to find a place to file those documents. So that's kind of my perception. And even when we call the court, there's more and more of an effort, I think, at cross training. People are expected to be able to do everybody else's job, and probate is just a little different. It's always been a little bit more relaxed. And I hope we don't get away from that.
I appreciate your comments. The meetings of the rules committees are published on our website. So I know it's probably a trip for you to go to Montpelier, wherever they're meeting, but I would encourage you to go there. Who's the chair of that committee? Do you know off the top of your head?
I don't know now. I actually did serve on that committee. And
Yeah,
also
I thought you did.
and also on the probate reform committee.
Yeah, right. I'd encourage you to follow through with the committee. If you think that the rules are awkward and not usable the way they are, this is the first I've heard of it, I have to tell you, but my ear isn't to the ground in the probate sphere. As far as probate being more available, this has been a concern, I know, for a number of years, since before we went through the restructuring. And I'm sympathetic to the concern. I practiced in probate court myself, and I know what you're talking about. It's a place where we all have the mindset that it's very available to people who don't have lawyers. But it's, I think, very much because of that you wind up with significant cultural differences between probate court to probate court to probate court. And, we are struggling with this, as the senator pointed out as well, we are struggling with this in every docket that is in the state, trying to make sure that we're harmonizing practice and procedure from county to county, and at the same time not doing so in a way that artificially creates barriers to people getting access to the courts. As a matter of fact, to the contrary, we're trying to make it more available. So I'm concerned about your comments, and perhaps you'd follow up with me after this, and you can give me more specifics about what you're talking about.
Well, thank you. I actually expressed my concerns to Judge Balave, and I asked if it would be appropriate. So he told me, yes.
Yeah.
And I asked him if it would be appropriate for me to meet with all the probate judges. He said the more appropriate forum would be the probate oversight committee.
Yeah, that's probably true. That's probably true.
And I wrote to them, I don't know, a month or so ago, not heard back.
And Judge Kilgore is the present chair of the Rules Committee with probate. If you're looking at a specific rule that you would like addressed, can ask to be put on the agenda for the next meeting.
Yeah, that's a good idea too. Jeff? He's in Washington County. Okay, thanks. You had a question?
Yeah, just kind of piggybacking on what you just answered, which is, I'm a foster parent, I'm in Wisconsin, here in Brattleboro, and we often wonder, my wife and I often wonder, we understand that you interpret the law as far as parents' rights as best you can, and you protect those rights, and so we're totally agree with it, absolutely agree with it. We feel very frustrated and can't seem to find that children in general have as many rights, or even a few rights, in corresponding with how many rights a parent seems to have. And so I guess I'm just kind of throwing that out there and wondering, do you feel that children in general here in Vermont are protected as much as they should be by law?
Yeah.
To the right and rights, they have the rights that they need.
Let me address this, because if you've got a pending case, it sounds like, I think. You got a pending.
I'm speaking in general.
Yeah.
But
you know that.
I've been a foster parent to many children.
I appreciate that. I really appreciate that. The interest of kids is, so far as I'm concerned, there's nothing more important. And we have brought a tremendous amount of attention and work to try to improve the system that we manage in the state. It's very, very difficult. If you're wondering whether or not children have constitutional rights in the same respect that their parents do, of course they do. Of course they do. But the balance, these cases are the most complex, most difficult cases courts see, bar none. And these are very, very difficult cases to work through. They're very difficult cases to complete because of the structure of the system. We've got attorneys who represent parties that have contracts in multiple counties at the same time. So when judges start hearings on child protection cases where they think that they're going to be able to finish the evidence in the time that's been allotted in an afternoon, for instance, and witnesses go beyond what everybody thought they were going to, we find that we can't get the hearings rescheduled promptly enough. And as a matter of fact, the Supreme Court issued a decision about 2 years ago where we talked specifically about this problem, that children are winding up in foster care, not a disparagement on foster parents, but they're winding up in foster care for too long. And, I know the legislature is very concerned about this. As I suggested a few minutes ago, they actually have carved out $7 million out of the most recent tobacco settlement. This has been in the papers. This happened a year ago, and they have charged the chief administrative trial judge in the court system, the commissioner at DCF, the executive director of the State's Attorneys Association, and the Defender General, with coming up with a plan to reform the child welfare system, as I think the senator would confirm. This is a big deal. It's a really big deal. But the process of democracy does not happen overnight. It just doesn't. And I worry about the same things that I can see in your eyes. I'm concerned about that too. But we're doing the best we can with what we have right now.
No, absolutely. I want to be clear. It's actually a very simple question. I'm just finding that, I am ignorant about all the laws, and I'm not a lawyer. I'm not a judge. I'm just a mom. But what I'm trying to find out is, does this kid that we're taking care of have the same rights that I'm hearing the parents' rights, the parents' rights, the parents' rights, and it's almost as if we're treating the child as property, and I find that despicable.
Yeah, no.
And and I know that we're trying to interpret the law as best we can. It's a very simple question. Do children have as many protections as the parents seem to have?
But sure they do. But what age are you talking about?
Right now, probably newborn to 19 months, 2 years old, little children who can't speak for themselves.
Who can't speak for themselves.
And so that, very complicated to understand. But they still have a lot going on, and they're still trying to tell us what's happening.
I would just encourage you, that's one of the good things guardians ad litem can do. We talk to foster parents a lot. We have the confidentiality, we have the ear of the kid's lawyer, who's it's their job to make sure the kids' rights are protected. And there are a lot of people who can't talk to certain people in certain situations, but we can talk to just about anyone. So I'd encourage you to talk, if you have real concerns, to talk to the guardian, let them see. I mean, we talk to foster parents a lot, and sometimes if it's hard to get a kid's lawyer to file a motion, because it's just not usually worth it, but it's worth bringing to the kid's attorney, for sure. And we can do it. We have the freedom to do it.
Yeah, that's a good, have you got a GAL involved?
Absolutely.
Yeah, good, good.
And I would just point out that in Vermont, every child in juvenile court has an attorney.
Right.
Most states, that's not true. Most states, kids do not have an attorney at all.
Right.
We really do take children's rights very seriously in Vermont. We're proud of it.
Thank you. Yes? Oh, I'm sorry. I think this lady had her hand up before you did, so.
Hi, I'm a member of the Juvenile Court Bar in
How are you?
Windham County.
Yes,
How are
of
you,
course.
Justice?
It's nice to see you.
Yes, nice to see you too. I just want to give a shout out to the legislators that are here, that it has been a discussion and a given in the Windham County Family Bar that we need more judge time and more resources in this court. Our judges work very hard, but they're very overworked and they need more time. And so I just wanted to bring that up in this county meeting.
Right now, you know, there are 2 vacancies we're waiting for the governor to.
Right, yes. So
Thank
I
you
just
for that.
wanted to bring
I
that up.
appreciate that. Thanks very much.
Thank you.
Yes, sir.
Hi, I'm Andrew Marshev. I'm a recent attorney, or a new attorney, I should say. When I was in law school, I had the privilege of working at the South Royalton Legal Clinic in South Royalton, and looking through the list of pro bono services, there's quite a few statewide ones, but I couldn't help but notice that the only one for Windham County is the Windham County Bar Association project, which is an excellent service. I actually represented a client through them in an eviction action, but it's just, you know, being from here, I graduated from high school here, and living here again, it seems to me like, and I've heard from a lot of folks, there's a lot of need here, and I'm wondering if there's a reason that there isn't something akin to the clinic or Vermont Legal Aid that's based in Windham County, if there's a historical reason for that, or if it's just that we don't have a lot of money.
I don't know that there's no legal aid office here, is there? There is none?
Springfield.
Springfield. Are you active in the county bar?
I am, yes.
Good. You know, I would tell you, I've been around a long time. This is, the people in this county, and this is really representative of what I would expect coming to Windham County to a meeting where, you know, the meeting we had a week ago, and I won't name the county, but it's not far from here. There were, I think, 6 people, maybe there were 8, right? And my bet is the population of that county is larger than this one. This is a county that has a real vitality to it, and I have tremendous respect for the bar here, because the bar, in my interaction with them, has always been very collegial and collaborative. So if there's no, if you don't see the kind of service that you would like to see in this county, I'd ask you to take up that cause and see what you can do about it, okay? And if you can, if you see something I can help on in that regard, just holler, because I'm in the book, you know? I'd be happy to back you up, okay?
And our county bar would love to, you know, talk with you more about how you would envision that and how we could play a role.
Thank you.
Well,
Can I ask a-
yes, please, yeah.
Hi, I'm Emily Kornheiser. I'm a new legislator from Brattleboro. And 2 questions. One, I'm curious, talking about sort of consistency around the state, if you have a sense of how expungements are going in Windham County compared to other spots. And similarly, wondering about drug court in the context of statewide conversations around the drug court.
So I can address the drug court.
Then we have Judge Treadwell here, who's our criminal division judge.
Well, Yeah.
Do you want
No, you want to talk about expungements?
Well, that might be a regular
We have
question for
Ann, who's our
the
clerk.
regional clerk.
So
I remember you talking about cutting microfiche, I think last time we had a conversation about
Well,
that.
that's up at public records. So right now, we're working on the process, and we're doing some of them. It entails someone going down and each file. So for example, if someone had a conviction on 4 counts, but only one was eligible for expungement, they have to go get the file, they have to go through the file, and they have to white out or remove certain things. So as you can imagine, we have over 1,300 cases we have to do that with. So it's going to take a long time. But we're doing the best we can. We do have someone that's working on it. We've got another person that's going to start working on it. It will probably take 2 or 3 people working a lot to get it done, because then the other process is unsealing certain cases and expunging, and that's the second part of the project. So,
Do you feel like there's the same resources as compared to other counties that are working on it?
yeah, I mean, I think it's pretty even how they distributed how we're going to do this among the courts. I guess if you look at numbers, for example, in Windsor County, they have over 1,600 cases that have to be expunged, and we have over 1,300. We both have one person that's dedicated to doing that. So I guess if you look at the numbers, it might be a little different. Chittenden had more people, obviously, because they'll have a lot more cases, but I think it's pretty even. It's just, it's not a quick and easy process, so, yeah. It's a great question, thank you.
So, drug court, do you want a drug court in this town?
Personally, I do.
You
yes.
do? So you need to get together with the state's attorney, the public defender's office, talk to people who provide services. We have a process, the Supreme Court does have a process to, you know about this, and we've got paperwork that I can send to you that, you know, and so the policy that we've adopted, that the court has adopted is, we're all for counties sponsoring drug courts, but the local people have got to find the resources themselves. We don't have the money in our general funds. That's number one. Number two is there needs to be commitment from the prosecutor and the public defender. And I'm sure you've heard this before. And it's a sort of a complicated question for some of them, for many of them. You know, I understand that the prosecutors run for election, and you know, sometimes that's a tough thing to do. But there has to be local buy-in. That's the fundamental point. There's got to be local buy-in. And then, you know, we'll look at it. We've got, I think, 2 petitions in front of us right now. One in Rutland, one in Chittenden. I actually have been down here a couple years ago. Wait a minute. No, it was at Bennington. It wasn't here. So I know there are a lot of counties that would like to see this. It's really a question of whether or not there's a commitment with the local folks to do it.
Do you think it's an effective model?
I'm sorry?
Do you think it's an effective model?
I think it can be if it's done correctly. But you know, one of the things that we know about it, and this is empirical, right? I mean, they've done studies across the country. If these courts are not run according to best practices, you actually could do more damage to the people who are participating than good. So it's really, this local buy-in is not just, it's not like a mountain we're trying to build in front of you. It's fundamentally critical to the potential success of the project. It's resource intensive, which is why, you know, I'd like to tell you that we could come up with some money. We can't. But there are there are grants out there. So I appreciate your interest. I think we're about to turn into pumpkins. So if we haven't already, I want to thank you all for coming. I meant what I said about Windham County. I'm sorry I was late.